Welcome to Legislative Report. I'm State Representative Kate Harper from the 61st District in Montgomery County. Today's Legislative Report comes from the House Urban Affairs Committee hearing in Bucks County at the Administration Building. We'll be talking about recording fees, which are charged by the counties when a homeowners association or a condominium association needs to file a declaration that affects all of the properties in the association. Chairman of the committee, Representative Scott Petrie of Bucks County, has brought together the recorders of deeds, members of condominium and homeowners associations, and lawyers to talk about the fees, which in some cases have increased by 1,000% over the last few years. These fees ultimately end up costing each homeowner in the association more money. So listen with me as we talk about this.
We're going to discuss today a particular issue with regard to recording fees associated with planned communities. We recognize that we have issues with regard to oil and gas leases. We also have issues in the state that make this a different issue for some communities. Here in Bucks County and in many of the contiguous counties in the southeast, the recorders use a uniform parcel number system. And they do that because it makes the searching of liens and easements easier for title companies, for banks, for attorneys who are representing buyers and sellers. But most of the state currently does not use the uniform parcel number system. It's something I personally believe that should be conducted statewide, but recognizing that Pennsylvania is a diverse state and there's many opinions, we will hear those opinions today.
By way of background, I am currently serving my third term as Commissioner in Chester County, beginning in 2008. Prior to that, however, I also served 2 terms as the Chester County Recorder of Deeds. And under my leadership as Recorder of Deeds, Chester County implemented the UPI, which is critical going forward in identifying all documents associated with a particular parcel. We also made significant progress in placing recorded documents online, with most records now accessible on the internet for individuals to search at any time and from any location. A little general notes about the Chester County Recorder of Deeds Office and its mission. The mission of the Chester County Recorder of Deeds Office is to preserve the integrity, accuracy, and continuity of the designated public land records of the county so that the public and businesses who work with these records can obtain accurate, timely information as efficiently as possible, and thus can secure property ownership and engage in business involving real estate with confidence now and in the future. There's some more detailed explanation in my written testimony, but I don't think I need to go into that right now. Essentially, the point of the County Recorder of Deeds Office is to enable any owner and the public to find the full set of filings that have occurred on a particular piece of property. This minimizes confusion when property owners have questions regarding their deeds and promotes a uniform understanding of what information can be found in which records, no matter what county one is in. Also, I would note that the first source of funds for many business startups comes from accessing the equity and personally held real estate, and banks will lend to property owners knowing that the real estate offered as collateral is indeed held by the individual who says he or she holds it. The presumption of clear title and the ability to insure it through title companies is further aided by this unique system of property identification and ownership. Let's talk about the UPI system. Under state law, counties may choose to implement a uniform parcel identification system, UPI, and about half of Pennsylvania's counties have moved forward with this investment. In this system, a UPI number is assigned to each separate tract, lot, or parcel real estate to allow the identification of a particular parcel of real estate by number instead of by legal description. This process offers better interconnectivity between the multiple offices that work with land records and makes it easier to identify the connections between multiple instruments with a given UPI and the county records that they reference. Once the Recorder of Deeds office receives a document, a UPI number is certified in order to ensure that the number on the deed or other instruments matches the county's records for the specified parcel of real estate. This involves working with the county's assessment office and mapping offices to compare several pieces of information found in the document to existing county records and to determine the accuracy of the information attempting to be recorded so that errors can be addressed prior to recording. There's some more documentation in my written comments, but I'll skip them. In terms of recording fees, the fees involved in recording a document are set in state statute, and a large proportion of the fees do not return to the county. The following fees are required to be levied on many types of document recordings. The County Record Improvement Fund, it's a special county fund, $2. Recorder of Deeds Record Improvement, special county fund, $3. Affordable Housing Fund, special county fund, with the county having an option to levy, but capped by state statute, $11.50. State writ tax, this goes to the Department of Revenue, 50 cents. This account is swiped by the state each day. Judicial Computer System Augmentation Account, it goes to the Department of Revenue, $35.50. The base fee to record a document typically applies per instrument for up to 4 names and 4 pages, exclusive of notations. Each name over 4 is 50 cents, and each page over 4 pages is $2. A county that has adopted a UPI system may also charge a separate fee for the certification of each UPI number affected by the recording by ordinance of the county commissioners. The UPI fee is the only fee over which the county has discretion. All other recording fees would require state legislation to change the statutory fee structure. House Bill 1101. When a condominium association files an amendment to its declaration with the recorder's office, each parcel needs to be indexed to reflect the change in the parcel history, in addition to the filing of the amendment. For instance, these amendments often reflect changes to the association's bylaws as adopted by the property owners, such as requirements for lighting, setbacks, or other property appearances, or in one recent amendment in my county, allowing the residents to disable their sprinkler systems if they meet certain requirements. House Bill 1101 would prohibit the county recorder of deeds from levying fees for indexing the information to each individual parcel. CCAP opposes this legislation because it creates a disincentive for counties to index this information. In Chester County, the base fee for recording an amendment to a declaration is $13 for 4 pages, plus the County Record Improvement Fund fee of $2, the Recorder of Deeds Record Improvement fee of $3, the state writ tax of 50 cents, notation fee of $2, and technical fees totaling $5, for a total base fee of $25.50. The $2 fee for each page over 4 applies as well, and if the amendment contains the word easement in the document title, then the $35.50 state fee for the Judicial Computer System Augmentation Account would also be applied. Some recent examples from our office. The second amendment for an association containing 6 pages and 9 UPI numbers totaled $202. The fourth amendment for the same association containing 5 pages and 3 UPI numbers totaled $110. The third amendment for a different association with the term easement in the title containing 3 pages and 27 UPI numbers totaled $466. One amendment with 3 pages and 146 UPI, which did not include the state judicial computer system fee, totaled $2,230.50. While an aggregate bill may be large, the indexing fee is the same fee per parcel that would be accessed on a parcel in a condominium association as on anyone else who needs to file a change to their individual deed. If counties are prohibited from accessing the fee per parcel to index the amendment to each property, in reality, it creates a fairness issue whereby other property owners that are not in communities are forced to pay the per parcel fee, while those in communities are not.
I'm an elected recorder of deeds from Dauphin County. The association membership includes the recorder from each one of the 67 counties in Pennsylvania. Recorders are charged with the statutory duties to maintain the system of land records and related recordings in each county. PRODA's interests are always to focus on its statutory duties in the preservation and the orderly recording of historical and legally authoritative open public land records. Recorders are the single official repository of documents or instruments touching upon an interest in real estate in each county. It is from those records that the ever-important chain of title can be determined. Our offices are open to the public, our records are open to the public. They allow a reliable, transparent review of each property in the county. The offices provide efficient and a live person which guide people to those records. These people include homeowners, lawyers, title searchers, title abstractors, as well as title insurance agents. The importance of maintaining reliable and accurate records cannot be understated, as we live in a transactional world where banks and lenders rely on real property as collateral. The buying and selling of real estate and other related transactions and loans associated with those transactions are often characterized as an engine of economic activity in our country. Our association hosts a number of educational seminars for its members and reviews and comments upon relevant legislation impacting our office, keeping in mind we are elected or appointed to serve the public. PRODA believes that House Bill 1101 creates winners and losers. By that I mean, with its passage, there will be some that are charged the UPI fee and that some are not. PRODA feels that that system is a little unfair to the recording public. To be clear, the recorder does not set the UPI certification indexing fee. Rather, the fee is established by county ordinance when a county converts from a traditional recording system to the modern UPI system. House Bill 1101 provides an industry-specific carve-out resulting in the waiver of a nominated fee pursuant to the Uniform Parcel Identifier Law, commonly known as the UPI law. The result of House Bill 1101 is a law which only some folks that record are charged a recording fee, while others are not charged to support a modern system of recording that is open and accessible to everyone. The UPI system is an advanced mapping of real estate for the purpose of identifying every property uniquely, and it also serves for orderly and accurate tax assessments. There are other uses of the advanced mapping system. One county relies extensively on its mapping system to pinpoint properties for 911 responders within their county. PRODA is suggesting to the committee that in considering House Bill 1101, the members be mindful of the following. Number one, fees imposed upon the general public are tied to each unique parcel, and the enactment of the UPI system in 1988 confirms this approach. Two, the UPI law allows the county governing body a choice to adopt or not by ordinance to establish a UPI system of recording real estate, therefore, and thereby modernizing its way of recording documents. Three, fees or costs imposed upon a recording public are set by statute or ordinance and are assessed and should be assessed upon each unique parcel identified for recording. Four, PRODA, on behalf of its members, welcomes the opportunity to continue to discuss recording fees and the management of land records with all parties in interest to study and develop practices and processes within the law to better serve the public. At issue, as you are aware, House Bill 1101 is the very system of recording and the corresponding fees and costs imposed by county that this General Assembly enacted in 1988. In Pennsylvania, the association is aware that about 1/2 of our 67 counties have adopted and operate this UPI system. The membership of PROTA was last surveyed on this question a few years ago, and we actually believe even more counties than half are considering converting to a UPI system. This modern recording system identifies every piece or parcel of real estate within a county with a specific number. The recorder maintains every recording related to each property and ties such recording to a unique number. That's called the UPI number. The public can expect, and this is the most important part we feel about the UPI law, in 100 years or even 50 years from now, we will be able to look at that unique parcel identifier, and we'll be able to track all transactions that happened with that parcel identifier. This committee can certainly appreciate the need for such a system when searching titles, using real estate as collateral for mortgages, and resolving any dispute as to ownerships, to name a few benefits of this modern indexing system. Recording in a manner that ties all documents to a unique property identification is done through a process known as indexing, meaning each recording is indexed to the unique number that creates a searchable public record to obtain important information about each parcel in the county. The other counties, the ones that don't have UPI, while perhaps considering the enactment of the UPI system, operate under the traditional form of recording, but nevertheless one requiring recorders to maintain and service a system of established public indexes, providing for an orderly, open, and searchable system of land records. In these counties, searching of properties is done by examining the grantor, the grantee. In other words, who's selling, who's buying, tracing the title to a property in this name. It is our opinion that the Uniform Parcel Identifier System is one that actually makes more sense in that it allows someone who, whether or not they're a title searcher or someone who is a member of the general public, now doesn't have to know the name of the person who owned the property. They just need to know the number. And in 50 years from now, you would plug in the number in our databases, and every transaction regarding that property, whether or not it be a deed transaction, a mortgage transaction, an order from the Court of Common Pleas regarding that transaction, an easement, all very important parts regarding that property would be under one number. It wouldn't have to go from person's name to person's name to person's name. Yes.
Theoretically, a fee, as opposed to a tax, is a payment for a service that the government offers. So in this case, they pay you a fee, you guys record the deed or the easement or the amendment to the declaration.
Yes.
Right.
That's correct.
And as the testimony showed, it's a lot of work to check and make sure that the instrument, the deed or whatever it is, gets recorded against the right tax parcel number.
That's correct.
So here's my nuts and bolts question.
Okay.
Does it take as much time to record the same document against 500 units in a homeowners association as it does to record 500 different documents all over your county? And if it does, why does it? It seems like there should be some economies of scale there.
Agreed, and that's a great question. In each document, each parcel, mainly within associations, or let's just say, I want to talk about it in a sense where there is multiple parcels. Each parcel is looked at mainly by the tax assessment department. They're the folks in most counties who actually look over the tax parcel ID and certify that it's the correct parcel ID number associated with each unit. Let's just take the condo association unit. So they have to actually individually look at that tax parcel ID to make sure it's correct and it matches the confines of the particular condominium that it's representing to do. I can't tell you enough times that there are a lot of documents that are submitted to us as recorders that the tax parcel ID is totally incorrect. So each one of those tax parcel IDs needs to be checked to make sure it matches the tax assessment records of each county, to make sure it's referring to that tax parcel.
Right, but
so I understand so there is an economies of scale because it comes under one document.
Right.
But the work is the same in that if it was
the
one document,
first four
one
numbers
parcel,
are going to be the same, right? Or the first 6 numbers are going to be the same?
it usually in our county, is a 2 number dash 3 number dash 3 number.
Right.
And so apparently you can obviously see that the first 2 usually refers to the municipality.
Right.
And so that's easy. But each one is looked up by the tax assessment department, at least in our county, or in the county recorder of deeds to make sure the last 3, which are usually the most important because it identifies a particular parcel within the municipality and a plan map, that those actually match and are correct.
So it does take maybe not exactly the same amount of work, but a lot of work to do each number in a 500-unit condo association.
That's correct.
If you had only one number, you know, if you had, the Bluebell Country Club had a number, a general number,
Master number.
whatever, you'd only have to look up one. Now, here's my question though. If I look up an individual condominium unit in that development, does it say that it's part of an association?
No.
Well, depending on the document.
No.
So we would hope that in 20 years from now, let me try to do it with an example, Representative. If a condominium association agreement, the initial one,
Right,
is
the
filed,
declaration.
declaration is assigned to the 500 parcels. So when I go to plug in a search by parcel number, that declaration would pop up on my database and for the public to see as to, okay, here's the declaration. Now, sometimes in an association, some things might touch other parts than others. For example, if you're purchasing the piece of property in an association that's next to a water basin or an area, you have certainly different worries than you do with somebody maybe 3 acres away, the same as part of the association, as you do as a person whose property is bordering the water basin and the sewer type of issues that they have there. So that's why we believe it's important to say each parcel affects different pieces. And so there might be a court case that comes down with an order that orders something to do with that sewer basin. That might not have anything to do with the folks over here, although if it affects the association, we still believe it should be indexed under each one. Because really, the association has to worry about all parts of its association. So you might have some documents that aren't necessarily connected, but they all are as part of the association.
Okay.
I hope
Thank
that
you.
answers your questions, Representative.
In the perfect world, it would be where they come in with a master document or a master parcel number, and once that master parcel number is put into the system, all units or all property within the condominium or within the PUD, they would all pop up, or it would automatically go feed into that unit number. That would be the perfect world. But
Exactly. Then you would record it against one number, so you'd have all the work that's required for that, but the public, to your testimony, would then be able to find it under,
Well, that would be, again,
they would pull up their own unit number, but it would pop up that they're connected to this other.
it would become under the
master
master
number.
number.
If I may, Chairman, with the discretion, although you are going to, if you do that, and I think that's a great idea, you're going to possibly have documents that wouldn't apply to one towards the other. So if a court order was enacted against a particular individual in the condo unit, all right, and say it's Jim Zugay, and that court order came down affecting me and my piece of sliver throughout that, that's not going to affect the 499 other members in that 500-member district. So that document, if you did a master, that document's going to show up. So in essence, what you're going to have is a system in which there will be a lot of, if you do it under that.
No, but if I was thinking we do a master number for declarations, bylaws, and amendments that affect the entire community.
Right.
And then you'd have your individual parcel for your mortgage foreclosure action.
That's correct.
Okay.
And as long as they could speak to each other, because you'd want one
Right, that's
under-
all I'm asking. Is
Right.
it possible to tie them so that if I was looking at my own property, I know where to find the other documents?
Right. I believe it is.
Under the parallel provisions of the Uniform Condominium Act and the Pennsylvania Uniform Planned Community Act, planned communities and condominiums are formed by the recording of a declaration in the Office of Recorder of Deeds of the county or counties in which the development is located. Any amendment to the declaration must also be recorded. The recording of the declaration and amendments to the declaration establishes covenants and restrictions which run with the land in that any condominium unit or planned community unit conveyed out of that development subsequent to the recording is subject to the terms of the declaration and the amendments. I represent numerous condominium and planned community associations and have been involved in the amendment process several times. The reserve at Upper Gwinnett condominium, located in Upper Gwinnett Township, Montgomery County, consists of 411 units. It was originally developed by Del Webb Homes, but ultimately built by Pulte Corporation. Both entities filed separate declarations, and when the homeowner elected board eventually took control of the condominium, it found itself saddled with two inconsistent declarations which did not clearly spell out unit boundaries and maintenance responsibilities. In order to address this issue, I worked with the board at the reserve at Upper Gwinnett condominium to create an amended and restated declaration. That document consisted of 75 pages. The document was recorded with an additional 25 pages listing parcel numbers. The base recording fee was the same $52, with an additional page fee of $192. In addition to that, the Montgomery County Recorder of Deeds assessed an additional parcels fee in the amount of $4,120 and a miscellaneous fee of $1 for a total recording fee of $4,365. And again, that additional parcels fee was assessed at the then current rate of $10 per parcel. At the current $15 per parcel rate adopted by the Recorder of Deeds, the current additional parcels fee would be $6,165 for a total recording fee of $6,410. The current statute provides for recording declarations in the grantor and grantee indices. That is a unique provision of both the Condominium Act and the Planned Community Act. For those counties that do use the UPI system, a master parcel number can be created upon the recordation of the initial declaration. Subsequent amendments can be filed against that master parcel number, eliminating the need for fees related to filing against multiple parcels. This will ensure a recording that, in fact, provides adequate public notice, addressing the concerns raised by the Recorder of Deeds, but at the same time eliminating excessive fees. Accordingly, I respectfully submit to the committee that House Bill 1101 and Senate Bill 1282, as modified by reference to this proposal of master parcels, be swiftly considered by the committee.
Well, that's all the time we have for today's program. This is State Representative Kate Harper, and this is Legislative Report coming to you from the Bucks County Administration Building, where we have, with the House Urban Affairs Committee, been discussing recording fees for condominium association and homeowners associations. Please be sure to check with my office on any legislative matter. The address and phone number will appear in just a moment. Thanks for watching. Join me again for Legislative Report.